In this video, I am going to choose before you most important questions and their answer on family law 2. Question number 1. Who are co-partners in Hindu undivided family and what are their rights? Can a son claim a share in his father's self-acquired property? Discuss. Friends, these questions have been taken from previous university exam questions and these are very important for coming examination of LLB. So friends, do learn these questions and answers, very helpful to you for your exams. So answer of part 1 is, a co-partner in a Hindu undivided family is a person, male or female, born into the family who acquires a legal right to ancestral property by birth, as per Mitakshara School. Following the 2005 amendment to Hindu Succession Act, daughters have also been incorporated as co-partnership rights as sons. It means daughters have also got the same right as co-partnership as sons. Now rights of a co-partner. Right to partition. Any co-partner can demand a partition of the ancestral property at any time. Second is right to joint possession. Co-partners have the right to possess and use the joint family property such as residing in ancestral home. All co-partners have the same rights. Right to maintenance. Co-partners are entitled to support education and marriage expenses from the joint family estate. Right to challenge alienation. Co-partner can restrain the karta, who is the head of the joint family, from improperly disposing of or wasting ancestral property. Right to account. During a partition, any of the co-partner can ask for account of the income and expenses of the joint property. Now, answer to the part 2. A son has a right to co-partnership ancestral property by birth, but he can demand his share in the ancestral property. If a father purchases some property through his own earnings or gets it from someone other than his immediate 3 generations of ancestor, it is his self-acquired property. So a son has no right to claim a share in his father's self-acquired property even if he is a minor. If the father dies intestate without leaving a will, the son, along with other class 1 heirs like daughters and wife, inherits the self-acquired property as a legal heir. However, if the father leaves a will, the self-acquired property passes according to the will. This is the answer for the first question. Now coming to second question. What is Hiba in Muslim law? Discuss essential conditions of Hiba and revocation of Hiba. State condition under which it can be revoked. So part 1, answer of the part 1 is, in Muslim law, Hiba is defined as a transfer of property made immediately and without any exchange, means without any consideration, by one person called donor to another donee and accepted by or on behalf of the donee. It is generally revocable before delivery. Essentials of Hiba. The donor must express the gift clearly. The donee must accept the gift. The actual position must be transferred. And fourth is, any sane person over 18 years can make a Hiba. Now, revocation of Hiba can be done only in 2 cases, before delivery and after delivery. A Hiba can be revoked at any time before the possession is handed over and after delivery. Once possession is transferred, a gift can only be revoked with the donee's consent or by a court decree. Now, there are some cases where it cannot be revoked. Hiba cannot be revoked. Number 1, if it is made to spouses, marital relationship. It is made to blood relatives within prohibited degrees. If the property is lost, destroyed or sold by donee. If the property has increased in value significantly. The donor or donee has died, and if it is a sadqa, that is charitable gift. In these conditions, a Hiba cannot be revoked. Now question number 3. Muslim marriage is a civil contract explained with judicial judgment. Like civil contract where we need proposal between the parties, consent, acceptance, consideration. So these factors are always in the Muslim law marriage, nikah. So it may be said that this is a civil contract because in Muslim law, Muslim nikah, in marriage, pro, proposal, there is proposal between the parties, mutual consent, there is free consent of both the parties, which is essential. Parties must be of the age of poverty. Dower, meher, that is, dowry is consideration as an obligation of the husband as a mark of respect forming part of the marriage contract. So this is consideration. Conditions. Parties can enter into valid anti-nuptial or post-nuptial agreement. So these are similar to the case of a contract. So Muslim marriage may be called as a civil contract. Now judicial judgment in this regard. Srimati Rahnuma and another versus State of UP and three others 2021. In this case, the Allahabad High Court affirmed that a nikah is a contract and adults have the right to marry of their own free will. Key requirements include free consent, two witnesses, and the absence of prohibited relationship. That means this is a contract. Civil marriage, Muslim marriage is a civil contract. Now coming to question number 4. Discuss the provision relating to intestate succession of a female Hindu under the Hindu Succession Act 1956. Now the answer will be key provisions of female intestate succession, section 15 and section 16, in which general cases are given. Section 51 says when a female Hindu dies without a will, her property devolves in the following order of preference. First, sons, daughters, including children of any predeceased son or daughter and the husband. Second, heirs of the husband. Third, mother and father. Fourth, heirs of the father. And fifth is heirs of the mother. Now, special exceptions. There are exceptions also. Section 15.2. It is given in section 15.2. Property inherited from parents. If a female Hindu dies without children or grandchildren, property inherited from her parent reverts to her father's heirs. Reverts to her father's heirs in case a female Hindu dies without children and that property has been inherited from parents. Property inherited from husband, father-in-law. In that case, if she dies without children or grandchildren, such property reverts to the heirs of the husband. So these are the two special exceptions under section 15.2. Now coming to question 5. What is partition in Hindu law? Who can claim partition, and if partition takes place, who are entitled to get share in such partition? Discuss. So the answer will be, it is partition. It is a process where a joint Hindu family breaks its joint status and the Coparcenary property is divided into distinct and separate shares. There are two concepts. You can divide this property. So there are two concepts. One is de jure partition, जिसको हिंदी में कहते हैं कानूनी विभाजन यानी कानूनी तौर से विभाजन. ये clear unequivocal declaration of a member's intention. Any member of the family who is clear and whatever he says is unequivocal intention to separate is enough to dissolve the joint family status. De jure splits the interest. It creates interest, separation of joint ownership and rights. It defines what is the ownership and what are the rights. For example, a court decree dividing shares of a family house. A court decree dividing shares of a family house even if all members continue to live under one roof temporarily. इसका मतलब ये है कि कोर्ट ने ये बता दिया कि भाई ये कमरा आपका है, ये कमरा आपका है, ये कमरा आपका है, आप यहाँ रह सकते हैं, आपके ये राइट्स हैं इस तरह से, लेकिन आप एक रूफ के अंदर एक छत के नीचे सभी लोग रह सकते हैं। सो इसका मतलब है कि पूरी तरह से उसका विभाजन नहीं हुआ। सो इसको क्या कहते हैं, डी जूरे पार्टीशन, जो कानूनी तौर से आपका अधिकार बट गया, आपके अधिकार बट गए और आपकी ओनरशिप भी हट गई, लेकिन एक्चुअली फैक्ट में ऐसा नहीं हुआ है। सेकंड इज डी फैक्टो पार्टीशन, ये ऐसा पार्टीशन जिसमें वास्तविक विभाजन कहेंगे, वाकई इसमें विभाजन हो गया, द एक्चुअल फिजिकल डिवीजन। इसको आप देख सकते हैं कि भाई ये घर मेरा है, मेरे नाम पर हो गया है, और ये भाई का है, ये खेत हमारे नाम पे, खेत उसके नाम पे है। तो दिस इज द एक्चुअल डिवीजन, एक्चुअल फिजिकल डिवीजन ऑफ प्रॉपर्टी इनटू स्पेसिफिक शेयर्स। de facto splits the possession. Now who can claim partition? पार्टीशन कौन क्लेम, विभाजन कौन क्लेम कर सकता है? तो देयर आर co-partners, any co-partner, male or female, who is major, वयस्क है, and of sound mind, can demand partition at एनी टाइम, इवन विदाउट ए रीजन। यहाँ रीजन की जरूरत नहीं है, बस उन्हें कह दिया कि भैया मुझे चाहिए, पार्टीशन होना चाहिए, बांटिए इसको, बटेगा। डॉटर्स, अकॉर्डिंग टू हिंदू सक्सेशन अमेंडमेंट एक्ट 2005, daughters are co-partners and have the same rights as sons to claim partition. Daughter भी इसमें भाग ले सकती हैं। Son, grandson, great grandson, male members of the coparcenary, इनको भी मिल सकता है, पार्टीशन में भाग ले सकते हैं। Minor co-partners, ये minors guardian can file a suit for partition if it is for the minor's benefit. कोई भी गार्जियन बनेगा माइनर का, जो बच्चा अभी 18 साल की उम्र नहीं प्राप्त किया है, मतलब 18 साल से कम है, उसके लिए कोई गार्जियन बनेगा और वो कोर्ट में एक सूट दाखिल करेगा कि मैं इनका गार्जियन हूं और इनके बेनिफिट के लिए मैं केस दायर कर रहा हूं, वो भी एक पार्टनर बन जाएगा, पार्टीशन का हकदार बन जाएगा। सन इन द वूम, अगर कोई बच्चा गर्भ में है उसको भी हम कंसिडर करते हैं कि वो भी एक पार्टीशन का दावेदार हो सकता है। एंटाइटल्ड टू ए शेयर। Father, a Hindu father can initiate a partition between himself and his sons, regardless of the son's consent. एक फादर के पास ये अधिकार है कि वो अपनी इच्छा अनुसार पार्टीशन कर सकता है संपत्ति का, रिगार्डलेस ऑफ सन्स कंसेंट, यानी बच्चों की राय के बिना भी वो अपना पार्टीशन कर सकता है। एडॉप्टेड सन, एडॉप्टेड सन जो गोद लिया हुआ पुत्र है, उसका भी सेम अधिकार है, द सेम राइट्स एज ए नेचुरल बॉर्न सन। Who is entitled to share in partition? All co-partners, the father's wife, mother, widow mother and stepmother, according to the Mitakshara school. She is also entitled to share equal to a son. अगर कोई स्टेप मदर है तो she is also entitled to a share equal to a son. Partition between father and sons, the wife gets a share equal to a son. अगर बाप और बेटों के बीच में बंटवारा होगा तो वाइफ को भी अधिकार है कि वो सन के बराबर, लड़के के बराबर, बच्चे के बराबर शेयर पाए। So friends, this was all about the important questions of family law 2. Hope this video will be very helpful for you for your exams. Thanks for watching this video.